It will be recalled that some media organizations, including the social media space, were recently bombarded with unsubstantial stories regarding the case of ex-Seaman Abbas Haruna with number M5759. Also, some unfortunate allegations have been made on the defense headquarters on the case involving the X-rating without finding out the facts of the matter from the appropriate quarters. Suffice to mention that ex-Seaman Abbas Haruna was a rating of the Nigerian Navy who last served under exercise Ayam Akpatuma, which was a joint operation under defense headquarters. I am here, therefore, to present the actual facts of the matter relating to the case of the ex-seaman to the members of the press. Let me, at this point, intimate you that the case involving ex-seaman Abbas Haruna started when he was found misbehaving during a parade. Specifically, the X-rating was part of the parade during a coordinating conference of the commanding officer when he was addressing troops of exercise Ayam Akpatuma, preparing for an operation. While the commanding officer was addressing the troops, the X-rating continuously interrupted the address, which warranted the commanding officer to direct him to report to the guard room. However, the rating refused to obey the order. Thus, the commanding officer directed his arrest, but the X-rating resisted and instead expanded 16 rounds of ammunition belonging to the Nigerian Navy, with the aim of preventing other soldiers from taking him into custody. Consequently, investigation was conducted and the X-rating was recommended to be tried by court-martial. The X-rating was eventually tried by a general court-martial from 20th December 2022 to 7th February 2023. Notably, the trial of ex-Seaman Abbas Haruna by the general court-martial was based on the authority that as serving personnel, he was subject to military laws. Ladies and gentlemen, ex-Seaman Abbas Haruna was arraigned before the General Court-Martial on 3-count charges of disobedience to particular orders, resistance to arrest, and offenses in relation to public service property, contrary to Section 56, subsection 1, Section 86, subsection 1, and Section 66, subsection C of the Armed Forces Act, CAF A20, Laws of the Federation 2004, respectively. At the trial, the General Court-Martial deliberated on the testimonies of the prosecution and defense witnesses, as well as the exhibits tendered by the prosecution surrounding the circumstances of the case. It is therefore important to note that the X-rating pleaded guilty to all charges during the trial. The General Court-Martial therefore considered the nature of the offense committed by the X-rating, his plea of guilty and plea in mitigation of punishment, as well as the legal advice of the judge advocate in arriving at its verdict. Accordingly, at the conclusion of proceedings, the General Court-Martial found ex-Seaman Abbas Haruna guilty on all counts. Based on this, he was sentenced to reduction in rank from seaman to ordinary seaman on count 1, and dismissal with ignominy on counts 2 and 3 with effect from 7th February 2023. Thereafter, The ex-rating was placed on open arrest at the arrival hall in Mogadishu cantonment, pending confirmation of the sentencing by the appropriate superior authority. Based on this, he has access to even his family, as can be attested during the appearance of the woman in a radio station. She said she had access to him. She even had babies for him within the period he was under open arrest. The record of proceedings of the trial was forwarded to Defense Headquarters on 27 June 2023 and subsequently transmitted to Naval Headquarters on 8 August 2023. The sentences of the General Court Martial were thereafter confirmed by the Chief of Naval Staff with effect from 19 September 2024. At this juncture, ladies and gentlemen, and for the purpose of clarity, permit me to give you a brief explanation on how the General Court Martial arrived at the sentencing of the ex-Seaman Abbas Haruna. The ex-rating was represented by a defense counsel of his choice in the name of Barrister Chukwu N. Augustine and Barrister Goji Esquire, and he pleaded not guilty to the charges during arraignment. However, before the prosecution could call their witnesses to establish their case against the ex-rating, his counsel made an application to the effect that the ex-rating wanted to change his plea. The application was granted, and the ex-rating changed his plea to guilty, thereby necessitating rearrangement. Despite the change of plea to guilty, the prosecution laid evidence by highlighting the various elements of each of the charges to be proved beyond reasonable doubt in the order to secure conviction against the ex-rating. At the end of the proceedings, the General Court Martial found the ex-rating guilty on the 3 counts. A common element which affects the jurisdiction of the General Court Martial, which must be proved in this fact, is the ex-rating was subject to service law at the time of the alleged offenses. This was established by the prosecution and admitted by the ex-rating. The other ingredients which the prosecution was required to prove this to secure conviction in respect of the ex-rating were that he disobeyed a lawful authority, resisted arrest, and willful damage to service property. Those ingredients were sufficiently established before the court and were neither challenged by the ex-rating nor his lawyers. It is pertinent to note that from the totality of evidence presented by the prosecution, the General Court Martial held that the ingredients required to substantiate the offenses were proved beyond reasonable doubt. Importantly, a perusal of the report of the prosecution confirmed that the accused rating disobeyed the order of his commanding officer and resisted arrest by firing his rifle to the extent that he expended 16 rounds of ammunition, which could have resulted in the death of any of his colleagues around there. It is therefore evident that the ex-rating cannot be trusted with a rifle or any weapon belonging to the armed forces of Nigeria. This is because soldiers, ratings, and aircraftmen are trained for the purpose of weapon handling to apply SEM judiciously and diligently when called upon for the protection of the sovereignty of the Federal Republic of Nigeria and not extraneous uses which could endanger others. Pertinently, it is opined that the ex-rating ought to have also been charged for attempted murder of everyone that was in the vicinity when he fired the shots. Notwithstanding, he was appropriately charged, tried, found guilty, and sentenced on 3 count charges presented before the General Court Martial. Furthermore, the confirming authority rightly confirmed the findings and sentencing in line with the Armed Forces Act.